months, and I'm really enjoying it. But I've been counsel a lot of different places. I was a prosecutor for 24 years in Jackson County. I was the chief deputy there. And I've really enjoyed the opportunity to study the law in my career. And I'm going to try to make it interesting for you, try to make it even funny, because there's a lot of stuff this year, and I want to go through it all. And don't worry, several people have asked me, are you going to call on me? And I said, only if you're asleep. So any of you that are asleep, I'm calling on you. Okay, legal update. Let's see if I can get this right. The first case is a really interesting case. It's the United States Supreme Court. It was argued in October, but the decision came down in May. And this is one of the few times that the Supreme Court has taken a great effort to change the law. And it is something, it's a very routine case, but the consequences of this, it's a use of force case, the consequences are radical because of what happens in the case and what they said about the case. And so the name of the case is Janice Hughes Barnes. That's the mother of the person who was killed, and in the estate of Ashion Barnes, deceased, petitioner versus Roberto Felix Jr., who's the officer. And it is such a basic case, it's really amazing to get it to the U.S. Supreme Court. Okay, here it is, 2016 case. Roberto Felix, a law enforcement officer patrolling a highway outside Houston, received a radio alert about an automobile on the road with outstanding toll violations. Pretty routine case, right? Not complicated. And Felix, the officer, spots the car, a Toyota Corolla. He turns on his emergency lights to initiate a traffic stop, and the driver, Barnes, actually pulls over. So he's got that going for him, right? And he pulls over, and here it is. This is taking from his report. Parking his own car just behind, he walks to the driver's side door, asks Barnes for license and proof of insurance. I know this will be a shock for you, but he didn't have his license. And the car was a rental in his girlfriend's name, of course. And Barnes was rummaging through papers, and you know how much you enjoy having somebody you stopped reaching down and taking out papers and reaching underneath the seat and doing all those things, right? And so he tells him, stop rummaging around. And of course, he doesn't. He's digging around. And the officer, with the window down, says, I smelled marijuana. And so he begins to explore that. And of course, he does the typical question. He asks, is there anything in the car he should know about? And Barnes responded, he might have some identification in the trunk. Why would you have your identification in the trunk? Well, there you are. So Felix, pursuing from reasonable suspicion to probable cause, he says, open the trunk. And he had turned off the ignition, Barnes had turned off the ignition, and you know it's a bad sign when he turns on the ignition. Again, while you're standing there, right? I'm sure you've all experienced that wonderful feeling. And so, and this is all on dash cam, of course, What happens next? Felix told Barnes to get out of the car. Barnes opened the door, but he didn't get out of the car. Instead, he turned the ignition back on. Felix unholstered his gun, our officer, and as the car began to move forward, okay, he jumps on the sideboard of the car, and his head is above the windowsill and all of that, and he has his gun out, and he puts the gun inside the car and fires twice, killing the suspect. Well, no visibility in the car, and by the time everybody got there, Barnes is dead, and the entire experience was 5 seconds. So it's a typical stop, and the entire totality of the circumstances, in this case, started very quickly and accelerated. By the way, the suspect owed money on a toll that he hadn't paid. This is not kidnapping, murder, rape, nothing like that. And he gets killed. And his mother and family think it's not something that deserves deadly force. Easy for them to say. Okay, so what happens? They file suit, and the trial court applied the Fifth Circuit Court of Appeals moment of threat application. And as you may know, different circuits in the United States have a different application of those things. So you have at the moment of threat, well, he's standing on the floorboard and it's driving away, right? And he pulls a gun and shoots, kills him. So the question is, the Fifth Circuit's using this at the moment of threat when he was standing on the doorsill of a moving car. And most people, I would say, at that moment he shot him, was there danger for the officer? Yes. Was there a decision that he had to make? Yes, there was. And based just on the fact he's on the sill and the guy's driving away, that's what they applied. They applied that at the moment argument. And the Fifth Circuit had used it for years. The problem is the U.S. Supreme Court had been waiting for a case to decide. And ultimately what the case happens, what they do, is they remand the case back to the trial court and say the Fifth Circuit applied the wrong standard, and so at some point the trial judge will get the case again and they'll probably have to retry the case. But I like this. It says, at the moment the court found an officer could reasonably think himself at the risk of serious harm. Everybody agree? I'd say that's serious harm. I had a case very similar to this a couple of years ago, and the Court of Appeals opened. It was bound by the circuit's moment of threat doctrine. So the moment of threat is what they applied. So it's just the average case that you know about, probably going to go through. The Supreme Court's not going to hear it. And guess what? They did. The Supreme Court says no to moment of threat doctrine. It's not the moment of threat, it's the totality of circumstances. Deadly force suggests that stopped person's conduct is always relevant because it indicates the nature and level of the threat he poses either to the officer or to others. And under the Fifth Circuit view, it's when they shoot him, or when they defend themselves, or when they defend someone else. And so that's that moment of threat. Well, the Supreme Court says, nope, not a moment of threat doctrine anymore. And why is this a big deal? Because all the other circuits, 8th Circuit, 10th Circuit, all of them have their own understanding of what's going to go on and how it's going to go with regard to issues of threat. Totality of the circumstances is the correct analysis for use of deadly force cases. Totality of the circumstances. Well, you analyze the deadly force under the Fourth Amendment because it's a taking. It's a taking of somebody's life, right? So you have taking of somebody's life, the use of deadly force. It's going to have really detailed analysis, and there's going to be all sorts of review. And of course, you use a reasonable officer at the scene. What do they think? What do they feel? Are they, under the totality of the circumstances, subject to a dangerous situation? We know that Tennessee versus Gardner is a Supreme Court case that was in 1985, and that totality of the circumstances really has been what the Supreme Court of the United States wants all the circuits to use. That's what they need. We want to have a totality of the circumstances, and you can look at this. In this case, there's an issue of time. And when I mean time, it's should they just look at that circumstance that occurred in that 2 to 5 seconds that happened? And the Supreme Court said, no. You have to look at the whole incident. Well, why does that matter? Because this guy was stopped for a routine toll road payment issue. It was nothing. And he gets killed. Now, the fact that I'm sure they argued that he was trying to run him over or trying to shake him off the car, which could have resulted in his death. But here it is. The totality of the circumstances inquiry has no time limit. In other words, it's not just the incident itself right there, those 2, 3, 4, 5 seconds. It's the totality of the circumstance. Well, what sort of things are we talking about? Well, you're talking about from the decision to stop the vehicle, asking questions, he turns off. Do you think he could have shot him because he turned the car back on? Is that going to be enough? No. You can't, well, he turned the car off and I thought he was going to drive over me. I don't know. That's not going to work. You have to look at this. Does the officer know anything about this guy? No. He doesn't know anything about the guy. Is he a kidnapper? No. Toll violations. Okay. The court does not address in a separate question about whether or how an officer's own creation of the dangerous situation. Did this officer create the dangerous situation? Well, he jumped on the sideboard. He knew who the guy was. He jumps on the side as he's driving off. They know where he is. They know who he is. Is that worth shooting him? And of course, under that threat doctrine, it occurred right as he's trying to pull away. The fact that he couldn't even see in on the guy to know what he was doing is a factor that's probably going to come out in the retrial of the case. Okay. Whoops. Let me go back. So, totality of the circumstances is the critical aspect of this. It's going to go back, but what it's going to say is you need to tell your deputies that it isn't just what happens in a limited period of time. Do you have prior history with this person? Has this person made threats to you? You need to put all that in the report. You need to argue that the totality of the circumstances convinced you this guy's dangerous. Well, now, I don't know what this guy's prior record is, but I do know that his family is going to gear up and go after the sheriff's department and this individual officer under 42 U.S.C. 1983, which is a section 1983 lawsuit, which involves totality of the circumstances, and they're going to argue that the officer went way over by shooting twice, killing him without any information as to the danger the officer was in. Look at this case. Okay, the next case I want to go into is something about distracted driving, and those of you who have been in law enforcement a long time know about 15 years ago was the first time we tried to get a statute about driving and talking on your phone and being distracted. And why is that? And I just did a few stats for you, and I have 2024. 954 people were killed in traffic accidents in Missouri in 2024. That's almost 1,000 people. And there are also road fatalities were down, but there was an increase in a rise of pedestrian deaths. And most of these are when people are driving, looking at their phones or talking on their phones, and they run over someone. Well, how many times has that happened? Well, we know for sure that pedestrian fatalities in 2024 was 148 people. Now, I don't know if each of them were distracted driving cases, but most of them were. I didn't look at all the different things. So it's a big deal. And so we passed in 2023, and this had been put on the legislative agenda a dozen times. And finally, in 2023, they passed this no distracted driving because you can't be on the phone, you can't do any of those things, and it was a huge deal. But of course, to kind of ease it in, they said, well, this is going to, we're going to review this, we're going to look at it, and it's eventually going to be actually something that you can write people tickets for where it's going to cost them. And there was a huge problem. And speaking as a lawyer, boy, the lawyers use their phone a lot. Okay, so finally, in 2025, you can start actually writing real tickets and actually trying to do something about the 954 fatalities and the 148 pedestrians. But like seatbelt law, you have to determine what they're doing based upon the initial crime. So in other words, you can't stop somebody because you see them talking on the phone. Now, if they're speeding, which they probably are, you stop them for speeding and then you write them. Okay, why does that matter? Well, it matters because the fines and the costs are way up there. And so you get all sorts of things. And whoever wrote this law, I don't know who wrote this law, there have been so many different things. It's a great evidence law because you don't have to prove this guy was talking on the phone. All he has to do is have the phone in his hand. If you see somebody as you drive by holding the phone, that's going to be enough. You don't have to prove he was talking to anybody. Can you imagine what the nightmare would be trying to prove that somebody was talking on the phone and where it is and what they say, all that kind of stuff? Nope. Nope. And so, see if I can do this. This is the Siddons-Benning hands-free law. Now, it took effect in August of 2023, but it's very specific. Holding a phone to text, call, or perform other tasks while behind the wheel. So for the first 16 months, right, the hands-free law violations would result in citations, but now they actually cost them money. First-time offense will be a $150 fine. The penalties will range from $250 to $500 for subsequent violations over 2 years. Now, and it still remains a secondary violation because people were so upset about their phones. But we are hoping that this hands-free law will stop these fatalities and distracted driving that have resulted in so many deaths. So it's a big-time change. And of course, you know there's a huge outpouring that they don't like this law because they worked it out so that it took us from 2023 to now to actually get it done. Okay. And I put the language in here. It prohibits drivers from holding or supporting electronic devices while driving. This means no texting, no scrolling, or even holding a phone while behind the wheel. So, it's a big deal. So that's going to be a big deal. Senate Bill 347, which has been big, is on expungement. Now expungement is 3 misdemeanors and 2 felonies. Now, obviously, the prior statutes say you can't get a statutory expungement for murder, voluntary manslaughter, all these other sorts of things. But what it does is it expands it. And there are people every year who want to expunge significant drug convictions. And that is why, and they fight this all the time, someone says, well, I don't have any criminal convictions. And they expunge 2 of them. Well, of course, we know that it'll say an expungement on our records, and for purposes of the expungement, it's true. It is what we call ab initio, from the beginning, not there. But we still get to see it on our websites because we want to know if somebody is a danger to the law enforcement people or whatever. Waiting time for expungement of misdemeanors, they now only have to wait 18 months, not 3 years. And it's from the date of the arrest rather than 3 years from the date of an arrest. Sexual conduct with a nursing facility, use of a child in sexual performance, promoting a sexual performance of a child, and cross-burning, those cannot be expunged. Thank the Lord. More discretion in the court. A court can no longer make a determination for expungement petitions solely based on a victim's testimony and can decide if the continuing impact of the offense and the victim affects the validity. Well, anyway, when the people come in, they want to get the judge to do it. They don't want to have to, they notify the prosecutor's office. Prosecutor can come in and object. But the problem of all that is there's so many things going on, and people want to get that done. And so they do that. Enticement of a child. And this is one, and again, you have to look, and we don't really have time to go through every jot and tittle of it, but this is an enticement of child penalties. And of course, a person is 21 years of age or older, so 21 and up, commits the offense of enticement of a child. So why is 21 a big deal? 21 is a big deal because you have people, now we have 4-year high schools, right? So if somebody's in 9th grade and is dating a senior in high school, then they go on to college, there's going to be the possibility that they're involved sexually. There's going to be issues, and we get into the dating issues, and the parents, some of them think it's okay, some of them don't. Some of them want the guy arrested and put in jail, all that kind of thing. But it's 21 years and up, commits an offense of enticement if he or she persuades, I like this language, solicits, coaxes, entices, lures, whether by words, actions, or through communication via the internet or any electronic communication. I have a son who's 30. He never talked on the phone to his girlfriend. They just text. It was constant. And as far as I know, I don't think he was doing anything, but who knows. So they did this enticement of a child. The defendant has to be 21 years or older, and that's going to be a big deal. And no person convicted under this section shall be eligible for parole, probation, conditional release, or suspended deposition or execution of sentence for a period of 5 calendar years. So, what this says is, and again, 21 or older, he can get up to life in prison, and it's kind of like, as I understand it, we'll see what the courts do with it. They're going to require 5 years of actual time that they have to do before they get out. 5 years. And so that's going to be a valuable tool. Okay, any person who's less than 17 years for the purpose of engaging in sexual conduct. And what do you think happens if the young lady or a young gentleman doesn't want to cooperate? Well, how are you going to prove they had sex? If she doesn't testify or he doesn't testify, how are you going to prove it? I'm just throwing this out. And on the prior statutory authority, it's not a defense to a prosecution for violation that the other person was a peace officer masquerading as a minor. They used to say, you submitted this, you articulated this as part of an operation, and the long and the short of it is this solicitation is part of kind of a sophisticated enticement, all of those kind of things. Let's see. And starting on January 1st, now, they've increased it. 2 felonies, 3 misdemeanors, and that's a lot. I represented somebody who had 42 convictions. I'm sure it was all a misunderstanding. But anyway, beginning August 28, 2025, they can now take their expungements. There's what we would call automatic on lesser offenses. And unless you're going to put a group together, and most people don't have the time, effort, or money to do that, people are going to get automatic extensions and get expungements of a variety of different statutes. There's a bunch of changes in the law. This next group are vulnerable person changes, and I put a bunch of these in here because, and you know, normally people don't do this, but I think it's something. The age for a child whose statement can be admitted in a criminal proceeding as substantive evidence has been increased to under 18, and it was previously under 14. Okay? The definition of a vulnerable person has been expanded to include individuals whose developmental level does not exceed that of an ordinary child of 17 years of age, up from 14 years of age. So that helps us on vulnerable children. Increased penalties for abuse of vulnerable persons. And as you may have seen in your jurisdictions, lots of people are struggling with what to do with their older family. And as a result of that, we have a lot of people helping a lot of people, and a lot of people stealing from a lot of people, and a lot of people entering into a relationship and absconding with all sorts of things, cars and houses and property and cash and all sorts of these. So they increase the penalties, and here it is. A vulnerable person, remember they've changed the law. Previously a Class A misdemeanor now carries an enhanced penalty of a Class C felony when the offender is a care provider who knowingly acts or fails to act, creating a substantial risk to the life, body, or health of the vulnerable person. You're not required to have medical help, but most of the people that I've dealt with will actually try to assist us in the prosecution of people they believe are being taken advantage of. Financial fraud. Huge. More and more and more. It used to be financial fraud was, well, that's civil, right? It's civil. You don't have anything to do with this. Well, here's just some examples. I just listed a bunch of them so you could see that. White-collar crimes in Missouri. Wire fraud, using electronic communication to carry out fraudulent schemes. Wire fraud can be state or federal crime. Just the use of the wire transfer of funds. Mail fraud, fraudulent schemes executed through mail service. I don't know how many times I've been solicited by people from Nigeria. I have nothing against people from Nigeria, but they want my money. And I can tell you right now that they're not going to get it. But mail fraud is big. And here's one, healthcare fraud, a huge issue. Overbilling insurance companies, submitting false claims, or other deceitful medical practices. Why? Healthcare fraud is enormous, and there is not very many people to investigate. And they don't have, I mean, you have billions of dollars in Medicare, billions of dollars in Medicaid, billions of dollars in all sorts of financial issues, and you overbill the insurance company. It may be 2 years before they can even look at it. And so, it's interesting. You hold up a Quick Trip, and it's armed robbery, Rob 1 ACA, right? And it's 10 to 30 years or life, right? Even if you just steal $10, $50, $100. You can steal $1 million from the medical association, and you'll be lucky if you can get any of the money back, and it'll be 2 to 5 years probably. So there's lots going on. What's another thing? Embezzlements. Misappropriating funds or property entrusted to you, such as a company assets or client funds. Embezzlement is huge. Embezzlement is trying to get people who are going to say they had the authority to do it and they misunderstood or whatever they did. Very hard to prove. Forgery. Altering or creating documents with the intent to deceive, such as fake signatures or falsify contracts. Now, forgery, I was a prosecutor back in the old days where, you had to see people, they would ink forgeries and they would transfer names and they would take old checks, they'd wash them, they'd put them in there and do all that. Nowadays, you have machines who can produce all this, right? And so it's a big, big deal. And it's very, very difficult. Money laundering. This is where you're concealing the origins of an illegally obtained money by funneling it through legitimate businesses. You're trying to wash it clean. Well, why do they do that? They do that because they don't want to pay taxes on it, or they want to do something. They don't want to say, yeah, I made this $10 million from narcotics, and so they put them in businesses, they let the businesses run, and they make a lot of money. Tax evasion, underreporting income or hiding assets. Obviously, the IRS is the number one group to investigate these, but there's also state crimes. And I can't remember, the last time I looked into our Department of Revenue, they had, I think, 5 investigators for the entire state of Missouri. What do you think the chances are they're going to check up on all that? Not very good. Not going to happen. Penalties. Well, we've got plenty of penalties. Restitution of financial losses, big deal. Probation, white-collar offenders may avoid jail but be placed on strict probationary terms. Well, and of course, in the state of Missouri, we don't supervise misdemeanors. So who's going to check on whether they're paying? We can certainly order them, and if we find out they haven't paid restitution, we can ask for a reduction. But at the end of the day, probation, imprisonment, federal crimes, penalties can even be greater. Legal consequences, a convict can tarnish an individual's personal and professional reputation, making future career opportunities difficult. Under Missouri law, embezzling funds over $25,000, which we finally did, to imprison for up to 15 years. Embezzlement is probably one of the most underreported crimes, because if you're a financial institution and one of your key people is stealing from you, Do you want everybody to know that before they come to you? No. Yeah, and I've had several situations when I was a prosecutor where they said, yeah, they stole $150,000 from us. We're going to make it up. We don't want him prosecuted. Well, but, you know, he's a criminal. Yeah, he's a criminal, but we don't want him prosecuted because we don't want people to think they can't take their money to this bank or this financial institution. And $150,000 is a lot of money, but it's nothing compared to our reputation. And there's lots of defenses to these kind of charges. Lack of intent is big. Well, I didn't know I couldn't take that money. I wanted to use that money to help people, and I didn't realize that I couldn't do that. Insufficient evidence. White-collar crimes frequently involve complex investigation, large amounts of documentation, and for most of the people in the sheriff's offices, it is very difficult to assign somebody to a large financial fraud issue and have boxes and boxes and boxes of evidence that you have to look through, right? And if you are pressured or threatened into participating in fraudulent activity, coercion or duress, that's what's happening. That's what they're doing. Entrapment. Law enforcement pushed or coerced you into committing an act you wouldn't normally have done, and this is part of entrapment, which is a valid defense in some cases. ACA. Armed criminal action is a felony charge that enhances the penalty for a felony committed with a dangerous weapon. What's a dangerous weapon? Well, guns, knives, large metal bar, all these sorts of things. And now sentencing of the ACA is tied to the underlying felony, and the penalty range can be 3 years to life in prison. Here it is. ACA is not a separate crime, but rather an enhancement of an existing felony charge, robbery in the first degree, armed criminal action. The sentence for ACA is determined by the sentence for the underlying felony and present. The amount of time that must be served before parole eligibility can be significantly impacted by prior convictions. For example, one prior prison commitment for a limited offense, listed offense, would require 40% of the ACA to be served. The statute of limitation for ACA is 3 years. So you can utilize it. All right? Any questions on anything I've gone so far? You're all looking very, very handsome, articulate, intelligent. Any concerns? I've looked at this. Anybody have any questions about any other statutes, any other issues? Can't see you out there. All right. Thank you very much. Good luck.